Good evening and welcome to the Drive at 5 on IntellectualRadio.com/iHeart radio station. I'm your host, Roman. We have a terrific show planned for you today. Please stay tuned to IntellectualRadio.com/iHeart radio station for Warriors Talk with Rochelle at 6 p.m. Tonight, my guests are attorneys running for a judge in Cook County. So I will get pivot to my right so they can introduce themselves, starting with.
Good evening. I'm Judy Lynn Smith, running for judge in the 5th Judicial Subcircuit.
Good evening, Deidre Bauman. Wonderful to be here. I am number 177 and I am running countywide for judge.
All right. So starting with you, Judy, please give intellectualradio.com/iHeart radio station your background.
I'd be happy to. Thank you. I have over 30 years of trial and appellate experience, which includes winning cases in the appellate court, as well as winning a seminal case on a no knock and announce search warrant statute, where the Illinois Appellate Court found that a subsection of the no knock and announce search warrant statute was unconstitutional. In addition, I've spent the last 18 years in the fire pit, so to speak, working very hard for my clients' constitutional rights as an attorney with the Public Defender's Office. I'm running on a platform of justice for all the time, justicia para todos, siempre. And I mean it. Justice for all the time includes fairness to all the time, as well as respect to all the time. I have the competence and compassion, and definitely the credentials to be your Judge Judy. And so I'd ask everyone to punch 194.
So, Ms. Ballman, Attorney Ballman, you've been
Yes.
no stranger to the Drive at 5. So please give intellectualradio.com/iHeart radio station an update since the last time you were on the drive.
Well, I'll just remind people of my experience. I don't have quite Judy's years in, but I have been practicing 29 years, doing primarily civil litigation, employment discrimination, civil rights work, and personal injury. I've tried over 50 jury trials, done over 50 appeals, argued before the Illinois Supreme Court as well. Since the last election, well, I've been working hard, of course, for my clients. I too am very, very concerned about equal justice and have seen a lot over the years and have seen clients not treated fairly for a variety of reasons. But I am running again because I believe it's my duty to improve the court system. And I did very, very well during the last election, receiving almost 250,000 votes. So hopefully this time I will be able to prevail.
So, Deidre and Judy, starting with Deidre, describe the duties or role of a judge. A lot of people don't understand the duties and a role of a judge. So, can you explain to us?
Sure. The role of the judge is to make sure that litigants are heard, that their sides. We have a system where we rely on attorneys in the criminal arena, the plaintiff, defendant, or in the civil arena. I'm sorry, the prosecutor, defendant in the civil arena, plaintiff, defendant, and the judge is responsible for making sure that justice is there is justice, there is fairness, there is equality in the court. And the judges, both Judy is running in the subcircuit, I'm running countywide, but we would be doing the same type of things, and we would start out in traffic, like most likely, and then move on to other areas of the court system. And judges touch everyone, from traffic tickets to divorce, criminal, etc. So the judge is there to do justice for all people in many, many different circumstances. Judy, you want to add to that?
Oh, certainly. And I certainly agree with everything that you've said, Deidre. But in addition, judges are supposed to listen with a blind eye, 100% listen to what's being said. It doesn't matter what the person looks like, where they're from, what their socioeconomic status is, who they know, what they know. The judge is supposed to listen to the facts as presented and then make a ruling based on that. And it is huge responsibility because it takes a large amount of maturity to do it and integrity and to not be afraid of what maybe the paper might be what might be said in a newspaper or how friends or family would feel. The judge has to do the right thing all the time, no questions asked. And and that's one of the reasons I think that I would make an excellent Judge Judy.
Agreed.
Thank you.
Why voters, Judy, should be concerned about selecting a judge in Cook County? A lot of people say, why go through this process? Is I don't know half of these doggone people in the voting ballot, voting booth. So I just pick a name that sounds good or
That
close to my ethnicity. So can you help us and explain why voters should be concerned about selecting a judge in Cook County?
and that in itself is the travesty of justice, quite frankly, because judges affect just about everything in a person's life. You will probably meet a judge before you meet the president of the United States, or you meet an alderman, or maybe even the mayor. And judges have to be competent. You have to be assured that this person has conducted trials, jury trials, bench trials, knows the rules of evidence, is learned, knows how to read a statute and interpret a statute. It's so important because your life literally can depend on it, and your freedom literally will depend on it.
No, that is absolutely right. And one of the reasons that we and others try to get out into the community, which is so important, is so people can meet us, can learn about us, can learn which candidates do have experience, which candidates are learned, and so forth. So, but it's a difficult process. I also say that running for judge, I think, is good for us, for the candidates, because we are meeting people, we are getting into situations that we otherwise would never experience, and it's so important to understand where people are coming from. So we are getting out into the community and learning even more than, of course, what we've experienced in 29 and 31 years, which is quite a bit. But yeah, it really is a good thing. Electing judges is a good thing if the information is available to people, and that's what we're trying to do to get the word out.
The bar rating. A lot of people are saying this person is not really qualified, but is still receive high marks on the bar. You mentioned qualifications, Judy,
Yes.
and you look on in black and white, and you'll say to yourself, in comparison to the persons that's not even recommended, what would you say to that?
Well, I would speak to my qualifications. I know that I'm qualified. I've been a trial. Well, I am a trial attorney right now, and I've done plenty bench trials, which are trials in front of the judge, plenty jury trials, as well as I had that next level experience that is invaluable, where I was an an assistant appellate defender, and I spoke of arguing before the Illinois Appellate Court and successfully getting a case reversed, for example, based on my oral argument before the court, as well as the briefs, the legal briefs that I wrote. And then, in addition, I spoke earlier about the case where the Illinois Appellate Court found unconstitutional a subsection of the no knock and announce search warrant statute that I wrote. So I know that I'm certainly qualified to be a judge because not only did have I done the trial
But
work.
despite what
Yes.
the bar is saying.
Hmm.
You're saying your credentials. We believe your
Hmm.
credentials. It's in black and white. You can look it up, go to the university, so forth and so on.
Sure.
But you have the Bar Association that has their own perspective of it. Do you
Hmm.
think it's too personal?
You mean the ratings
Yeah, the ratings.
from the
Do you?
bar
Yeah.
associations? I I think that the ratings from the bar associations are subjective.
Yeah.
They're subjective.
Go ahead.
I completely agree with
Mhm.
that. Um, I look at it this way.
But people
Uh,
follow it to. I'm sorry
they
to
do,
to
of
the T.
course, of some people follow it because they don't know any better. They don't realize that, well, everyone has, I don't want to say an axe to grind, but we're in a very political system. And I'm not casting blame on anyone, but everyone does have an interest. So I tell voters, look at an organization you trust. If you trust the Council of Lawyers, for example, maybe you want to consider their rating. If you trust the Independent Voters of Illinois, Independent Precinct Organization, IVI, look at their rating. Consider the ratings in totality. There are some people who may not have perfect ratings. There's some people who may have chosen, for whatever reason, not to go through the rating system because they think it's unfair or what have you. Um, but it's also critical to go to those candidates' websites to learn about the candidate. What has that candidate done in their career? Or have they tried a case? Have they done an appeal? Do they know the law? So, we're, as attorneys, we're all most of us anyway, we're A+ kind of people. We want to get that best grade, but there really, I would suggest, very little correlation between um, someone, and there are exceptions, don't get me wrong, but someone who is highly recommended and recommended, probably, I don't know if one rating would be a prediction of a better or worse judge.
You want to add to that?
No, I don't think so. I do think that they are political, especially since we are in a political climate here in Cook County.
But it shouldn't be.
Well, you say that, but it is what it is. It's still,
Mhm.
I do believe that they're political and subjective.
A lot is going on in the courtroom and in the news, especially the topic of the Supreme Court Roe versus Wade. And his court opinion, and I got a chance to read it, Justice Alito wrote, and I quote, Roe expressed the feelings that the 14th Amendment was the provision that did the work, but its message seems to be the abortion rights could be found somewhere in the Constitution, and the specifying its exact location was not of paramount importance. He also wrote, Alito declares that one of the central tenets of Roe, the viability distinction between fetuses is not capable of living outside the womb, and those which can, makes no sense. My question is, when it comes to legislation and the Constitution, the word specificity, you got to be very specific, comes to mind. That wording is very important to a legislation, and it cannot be vague to leading into interpretation. Your thoughts on the wording in the Constitution or legislation that you have to abide by? Because again, it has to be very specific, not vague. And in his and to his credit, he said there is nowhere to be found to interpret to our listening audience, the word abortion in the 14th Amendment cannot be found. I know you want to jump in. I just want to get Judy first.
Go
Well,
ahead.
maybe go to Deidre first, and I have something to say.
Oh, go
Yeah,
go ahead.
yeah. that is not the way that I view the Constitution. That is an originalist intent interpretation of the Constitution, that if it doesn't explicitly state within that document, it doesn't exist. I do not believe that's what our framers intended. I believe that the Constitution does reflect progress in society, does reflect changing values and mores in society. So I don't agree with that opinion at all. In terms of legislation does need to be very specific. But oftentimes, no matter how hard you try, it is not as clear cut as you might seem. And that's one of the reasons we have judges. And that's one of the reasons we study statutory interpretation and case law and so
So
forth.
if the word abortion is left out of a legislation, just like I'm going to use this because coming up, um, civil rights is coming up next. A lot of people fear that interracial marriage is coming up, and the wording. Some blacks doesn't view themselves as black people, so the word race, is it up for interpretation? Is it because they say race, color, or creed? Is people who don't identify themselves as race, are they left out? What's going on? You're smiling, so I go ahead with you.
No, I would look. I am a Jewish candidate, and there's always that debate. Well, is being Jewish a religion? Is it a race? There are always going to be differences in opinion on that. And go ahead, Judy.
And what I would add is, as far as statutory interpretation, as judges, we are to look at the plain meaning of the words of the statute. And so, just an example, the case that I was talking about, the no knock and announce statute, I found the wording of the statute, that particular subsection, to be vague and therefore unconstitutional. So on appeal, that I argued that we are to look at the plain meaning of the words. And then, of course, I bolstered it with some case law and everything. So the main thing is to look at the plain meaning of the word. And you need judges who are going to interpret, who have common sense and competence to interpret the legislation, the statutes and the laws as they're written.
So when it comes to Roe versus Wade or any constitutional law, can the five justice can be overruled, and the law can federal law can be put back in place? How can a person or a law can do it if the highest court already ruled?
Well, this is one of the most shocking things about the Dobbs decision, is that the Supreme Court, I would argue, on a political basis, overruled 50 years of precedents. And no, there is no higher court that can overturn what they just did. However, what they also said in that opinion is that this is now an issue that will go back to the individual states, and abortion and choice should be more of a democratically recognized right. I don't agree with that, but what we're going to see now is fights in the various legislatures, and we're going to see probably state law constitutional challenges to various rights, as opposed to the federal constitutional challenges, because some state constitutions can be read more broadly.
I agree.
The 14th Amendment in the U.S. Constitution ratified in 1868 granted citizenship to all persons born or naturalized in the United States, including former enslaved people, and guaranteed all citizens equal protection of the laws. One of three amendments passed during the Reconstruction era to abolish slavery and establish civil and legal rights for Black Americans. It would become the basis of many landmark Supreme Court decisions over the years. That is according to the History Channel definition um, of it. What are your thoughts on the first 14th Amendment that is a stepping stone in landmark decisions, starting with you, Judy?
Well, the 14th Amendment is part of is adopted by the Illinois Constitution as well. So what are you asking me?
I'm asking, is giving the rights in the 14th Amendment is a stepping stone for landmark decisions? You wrote the no search warrant
Oh,
type
yes,
of thing, right?
subsection, yes.
So anything in the 14th Amendment that you pulled out that cause a land making decision, a landmark decision such as yours?
Well, yes, you have to, the statutes, in order for people to follow the law or to even understand the law, they have to be plain. We have to be able to understand it. So if something is vague where we cannot, where anybody would be, oh, let me just restate this a little bit. Statutes and laws and rights have to be clear, and we have to be clear on whatever conduct we have, whether or not that is against makes it against the law. I guess what I'm trying to get at is, for that particular case that I said, the statute said that a person could not have any kind of protection mechanism, basically, on their door that was against the law. So that's against my client's right to be safe and sound in his or her own home. And it just didn't make any sense. So when we're talking about 14th Amendment rights and due process of the law, we have to make sure that people can can live and do things that are just proper things to do in order to sustain themselves and live. Did I answer your question?
Yes, you
Okay.
did. Yeah.
Yeah, no, I agree with that. And I think the 14th Amendment actually, and I think this was brought out in the decision, although I haven't read all 200 pages yet. But, Roe was based on privacy concerns. And the 14th Amendment arguably can acts in slightly a slightly different way. And yes, certain rights can um, be broadened based on the 14th Amendment.
The 14th Amendment goes further to state, and I quote, that authorized the federal government to punish states that violated or abridged their citizens' right to vote by proportionately reducing the state's representation in Congress, and mandated that anyone who engaged in insurrection against the United States could not hold civil, military, or elected office without approval of two-thirds of the House and Senate. The 14th Amendment has been the focal point of many rulings over the years, including what happened in January 6th, and it's been overturned recently. Why some judges are not following the 14th Amendment that is so clear cut? You want to start, Gigi?
I, I'm not going to say it's clear cut. It's not. Again,
What
when
is
we're
not clear cut that we can understand?
the language does not identify all the specific rights that emanate from that amendment. So it's really it's broader. Is that
it's broader, and then since it's broader, it's open to
Right.
interpretation of the individual judges.
So, okay, as a person being for judge, most walk through a tightrope, especially what's going on in the news today. And let's say it, okay, I understand there's a difference between church and state. So I'm just going to say the Bible can be like interpretation depending on the pastor and stuff like that. So you're saying if you're a judge and you have a personal belief,
Mm-mm.
no.
Mm-mm.
I can. I apologize.
No, go ahead. Go
I
ahead.
apologize for cutting you
No,
off.
no, no, no. Because actually, that's where we're going. Because some people think the ruling of Roe versus Wade, the ruling of the Miranda rights recently was personal opinion. And go ahead, Dove.
And therein lies the
Mm.
problem. Judges, I know as a judge, and I'm sure Deidre also, I know I can speak for you on this.
Yes.
We will make our rulings and findings without regard to politics, race, religion, gender, sexual orientation. We are going to look at what is presented to us and apply it to the law. That's it. Not, my religion, my religious beliefs will have nothing to do with my rulings because it is really and truly for both of us about justice. That's not justice. If I put my religious beliefs in, or if I don't like what this person is wearing and I'm going to rule a certain way. Oh no, the facts for me. It's about the facts in the law, and that's it.
Very well said. That's very well said. And personal predilection is not a consideration. Now, that doesn't mean that we don't bring our experiences, our backgrounds to the cases that come before us. You know, the jury instructions themselves tell the jurors you may consider your own individual experiences in life in determining the reasonableness and so forth of whatever they're present with what they're presented. And so, to the extent judges have discretion, we use our background, our common sense, as Judy alluded to earlier, and our knowledge to arrive at the right decisions based on the law and based on the facts. And what we're also both saying is that it is so important that we hear the facts from the litigants who come before us, regardless of creed, color, religion, and what have you. Here, with open ears, open mind.
Miranda's recently Supreme Court ruled that police officers cannot be sued for Miranda rights violation. Just in case, Miranda rights, if you go see cop shows, you may see an attorney. You're under arrest. You have a right to an attorney. If not, one will be provided for you. And some police officers do not use their Miranda rights. Now, this is considered federal. It's been overturned. What are your thoughts when it comes to Miranda rights? If someone doesn't know his or her rights, that an attorney can be provided for you. If it's not even read, you're frowning up on that. So you want to respond that.
Well, as a criminal defense attorney, that well, so you're asking in terms of as a judge,
I'm
or
asking as in terms of not only as a judge, but also as an attorney that represents the defense, and possibly because a lot of people don't know their rights or rights in the Constitution. And right now, the Supreme Court have thrown out that the police, if they're not giving you your rights when they arrest you, it's usually the case is dismissed or something to that effect. But now they're saying the police cannot be sued and the case will not be thrown out. You want me to pivot to Deidre for a minute?
Well, I'll just say I can't, I have not read that decision, so I can't comment. But historically, there's been a distinction. Um, any evidence obtained after the Miranda, I- if someone is in custody and being interrogated, any statements that are incriminating to them, if they are not given their Miranda rights, would be thrown out of court. That's different than me as a civil rights attorney affirmatively suing the police for a technical violation of Miranda. So again, I'm not sure how exactly that case was worded, but there definitely is a distinction between using the statements during a criminal proceeding and um, while also not allowing people to move forward in a civil context.
And not receiving the Miranda rights, that's something that the client would have to tell the defense attorney. The defense attorney would file a motion, and that would be presented to the judge. And the judge, after hearing both sides, would determine whether or not those statements or should be quashed or suppressed. So that's how that would work in the criminal on the criminal defense side.
But what if they don't know and they're locked up? The ruling has been, but their Miranda rights has been violated. So how does that work?
The client would have to tell the attorney, his or her attorney, that the officer did not read me my rights. When the client does that, the attorney is the one who files the motion. I mean, the only way for a motion to come before the judge, because the person wasn't given his a motion to suppress statements because the police officer didn't give them Miranda rights. The only way that can happen is if there's communication between the client and the attorney, and of course the client would have to tell the attorney that, and of course give the circumstances behind everything.
So the more information they a defense attorney knows, the better.
Oh my goodness, yes, 100%. And I understand a lot of times clients don't necessarily trust anybody. Once you're arrested and locked up, you're hard pressed to trust anybody. But if you can trust anybody, it's your attorney. You have to tell your attorney everything. And that would be something that's very important to tell your attorney, because your attorney can turn around and present a motion to the court.
Want to add?
No, that's correct.
So, Deidre, as a civil rights attorney, what are your thoughts? And I know you have to walk a tight rope with this. What are your thoughts? What just happened with the rulings of Roe versus Wade and the Miranda rights? And I know you admitted you haven't read all of them,
Mhm.
but a lot of people are feeling that their rights are slipping away, mainly women and minority women as well, um, particularly Black and Brown women. So,
And they'd be absolutely correct to feel that way, given the recent ruling. The with the Roe v. Wade being and Casey being overturned, women no longer have a right to choose to terminate their pregnancy, and that is there on so many levels. That is a problem. As a civil rights attorney, I am concerned that will the same type of reasoning that the court engaged in will affect, for instance, Obergefell and same-sex marriage and other cases where that reasoning was used. So that puts that in jeopardy. But that's also why it's so important now for people to realize and to study who they're electing, not only judges, but the legislatures in each of the states. Because the legislatures are, it's going to be, they're going to have a tremendous influence over the rights of a woman to choose what to do with her body. And I may not agree with it, but that's what it's going to come down to. And
There,
judges, as I said before, may be looking at these issues in terms of state law, constitutional rights. The other thing is the federal government can enact statutes um, to reinstitute certain rights. We have a Civil Rights Act. We have employment discrimination statutes and so forth. It can go that way as well.
I'm glad you brought it up. The FDA has an abortion pill, and now South Dakota is trying to ban it. So, quickly, your thoughts on that?
Well, we'll see what happens, but it looks like the federal government is going to step in and hopefully um, make sure that that does not happen.
That I think is what is going to happen. I'm hoping that is what is going to happen. In that situation, it goes beyond the state interest. The state may be able to prohibit within the state, but whether they can then tell people they can't go to other states or they can't receive the abortion pill through the mail or what have you. I think that's a whole different story, and the federal government most likely will step in.
We got to have the dynamic duo back. So please give
We've known each
intellect.
other a long time.
Yes, we have.
So please give intellectualradio.com/iHeartRadio station your punch number and how they can get a hold of you.
Oh, thank you so much. Judy Lynn Smith, punch number 194 for justice for all the time, justicia para todos, siempre. Please take a look at my Facebook page, Judy, Judie, Lynn, Lyn, Smith for judge. You'll see a lot of good stuff like a town hall with former clerk Dorothy Brown, as well as a huge endorsement from someone in the Hyde Park community. And you can also take a look at my website, which is www.judy, Judie, number 4, judge.com. Punch 194. Thank you.
Please vote for Deidre Bauman. I am 177. You can find more information at Bauman for Judge. That's BAUMANNFOR Judge, JUDGE.com. 177. I am the voice for equal justice.
All right. And when we come back, ladies, don't be a stranger to the Drive at 5. When we come back on the Drive at 5, more with sports author Anthony Sorton after this short break.
My name is Joseph Michael Carr, and I'm running for state rep in the 25th District. The 25th District is my home and where I raise my family. I deeply care about my neighbors and want to see my district thrive. That is why I support safety net programs for families facing economic hardship. I believe housing is a basic right, and everyone should be able to afford a place to live in dignity. I support access to early detection of mental illness because that is the cause of so much pain in our community. I support an end to predatory lending that preys on our most vulnerable. I support funding early childhood education programs that prepare our children for a new workforce. As a small business owner myself, I support entrepreneurship and financial literacy training for those with aspirations to start their own small business. As your state representative, I will be the link to the resources that you need. I am Joseph Michael Carr, and I approve this message. Please vote and punch 72 on Tuesday, June 28th.
Paid for by the committee to elect Joseph Michael Carr.
Hi, I'm attorney Richard Boykin, and I'm running for Cook County Board President. Cook County is at a crossroads. President Preckwinkle has failed to keep us safe. Gun violence, carjacking, retail thefts, and other crimes have terrorized our neighborhoods, where our children are dying in the streets and families are not getting justice. As a former commissioner, I fought against the regressive soda tax, and we won. And I will make our neighborhoods safer. It's time for real change in Cook County. I ask for your support on June 28th.
Paid for by Friends of Richard Boykin.